For more on the legal implications, we're joined by senior investigative correspondent Catherine Herridge and CBS News legal analyst Rikki Klieman. Rikki, I want to start with you. You've been a prosecutor and a defense lawyer. So what stands out to you now that you've read this indictment?
I think what stands out, obviously, is the magnitude of detail in this indictment. It's not only that you're dealing with 31 counts under the Espionage Act, which simply means the unlawful, willing retention of classified information or even unclassified information that would hurt the defense of the United States and aid our enemies. It's the detail of a speaking indictment. We have to remember that much of this indictment, John, is to educate not only ultimately a court and jury, but it's really to educate the public. Much of this indictment, in terms of the detail, may not even come into evidence in terms of what's admissible or not in the course of a trial. What also strikes me, John, is the overwhelming detail leaves the Trump legal team with real need to have powerful motions to dismiss. Because if this goes to trial, the way it reads, it's rather overwhelming for anyone to be able to fight it on the facts themselves.
And I want to get to that motion to dismiss question in a moment. But Catherine, you've been doing reporting about the risk assessment, about just what was in these documents. Educate us on that.
Well, what jumps out to me, John, is when you go to the section on the willful retention of national defense information. By my count, there are 21 top secret documents, and the disclosure of top secret information has the expectation of exceptionally grave damage to national security. But what else stands out to me is some of the classified codings like TK or talent keyhole. You don't see that very often. That's about intelligence from overhead imagery. For example, if we're looking at a terrorist target, do we have such good visibility that we can count the hairs on their head? Can we see what they're eating for breakfast on their terrorist patio? Those are capabilities that we don't want our adversaries to know that we have. And then also special access programs, or SAP. These are highly restricted programs because of the sensitivity of the intelligence and the technology, such as stealth technology, for example. Think of classified information like the Pentagon. Special access programs are these handful of rooms where there's just a limited number of keys to control and restrict access to that information.
So it's not just secret, it's the top of the top.
Some of these are way beyond top secret. Like I said, talent keyhole, when you're talking about special access programs or SCI, sensitive compartmentalized information, these really are the crown jewels of the U.S. intelligence community.
Rikki, let me ask you about a part of this indictment which comes from one of the former president's lawyers. Educate us on the crime fraud exception, how it's possible for a prosecutor to have this information, and is that a weakness? Because we know from our reporting that this is something that the Trump defense team is going to talk about, is the behavior of the prosecutors.
We all believe that when you go to a doctor, that there's a privilege, that what you say and what your ailments are will remain confidential. Same thing if you go to a clergy person. And it's exactly the same thing when you go to a lawyer. You believe that if you are a client, that what you say will never be disclosed to anyone, let alone in a grand jury or a court of law. It's called the attorney-client privilege. It protects all conversations relating to legal advice. So how did it get broken? That is, how did a court in Washington, D.C., a judge, and then an appellate court affirm the idea that you could hear, listen, read the notes and the voice memos of a lawyer to testify against his own client? It's called the crime fraud exception. So what the court believed was the conversations between Evan Corcoran, the lawyer, and Donald Trump were really in furtherance of a crime or a fraud. And he was ordered and forced to testify. Now, one could say, well, that's one and done. So now Mr. Corcoran is going to be a witness in this case should it go to trial. But we have to remember that that took place, that decision, in the District of Columbia. Now we are in Florida. So can it come up to a new judge? And might a new judge decide that it is not admissible at trial? Yes. Will that hurt the case? Not necessarily. There's plenty of other evidence.
Catherine, I've got two questions for you. The first is, what happens if you're just a regular old Joe and you have this kind of information? Legally, what happens to you? What's happening?
Well, as one example, I have contacts who work in the nuclear weapons capability arena. Let's say you have a nuclear document, it's on top of a photocopier. You walk away, you leave it there. Your clearance is gone, you are out the door. There are immediate consequences.
Let me ask you about a number of the president's defenders. Well, first of all, we should note the current president is under investigation by a special counsel. We don't know much about that, but Republicans have brought that up in defending the president. They've also brought up the case of Hillary Clinton. You've been looking at that. Give us a sense of the apples and oranges or apples and apples in comparison with what's on the table
Well,
here.
what strikes me, John, in this indictment is I think the special counsel Jack Smith specifically charged willful retention of national defense information in an effort to sort of blunt criticism that these cases may be the same. If you go back to the summer of 2016, then FBI Director James Comey said that they found multiple email chains on Hillary Clinton's private server that she used for government business that contained highly classified information, including these special access programs that we just discussed. But in his view, it should not be charged because he didn't feel there was sufficient evidence of intent or willfulness. Critics would say that even just purchasing the server was an example of intent. And then finally, you have to look at just the scope of the information and also the timeline. But I think this charging of willful retention really is by design.
Right. The facts of the case quite different, but thank you so much for that and for all your other answers. And Rikki Klieman, thank you.